Hello and welcome to the IP Australia podcast, and this is our series for small business and startups. My name is Lisa Cohen and I'm the Director of Public Education at IP Australia. For those of you who aren't familiar with IP Australia, we're the government agency that administers intellectual property rights, or IP rights. Now, before we dive into the episode, I'd like to acknowledge the traditional custodians on the land from which I'm coming to you today, which is the Ngunnawal and Ngambri people in the beautiful ACT. Now, in this episode, we'll be discussing how you can protect your innovation or invention with patents and the benefit of protecting your patentable ideas. I'm not sure if it's patents or patents, so that might be one of the first questions we ask our subject matter experts. Today I have two subject matter experts joining me. We have Lachlan dialing in from Melbourne and Sam, who's joining me in the studio in Canberra. So let's get started. Welcome to the show.
Thanks so much, Lisa. Pleasure to be here.
Thanks, Lisa. It's a joy. Very excited to talk about this field.
The funny thing is, for our listeners, I'm so sorry if this comes across, but we just love talking about patents. We're all IP nerds here, and we hope that you're going to take away a lot from the conversation today. But I'm going to ask a hard question of you, Lachlan, straight up. And the hard question is it patent or patent?
Lisa, when you said hard question, I didn't think you'd be asking me the hardest question. Truthfully, I don't know. If you listen to me speak over the rest of this podcast, I'm going to swap between patent and patent. I think both are correct, but I'm never sure which one.
Yeah, I definitely say both. I think I've heard that it's the whether you go the British pronunciation or the American pronunciation. So,
well, we're totally inclusive here at IP Australia, so we will switch between the two. That's fantastic. Okay, look, Lachlan, maybe, to turn to the seriousness of the call. Today, what is a patent?
That's the question that I thought you'd be asking. Well, what a patent is it's a legal protection. It gives you exclusive rights for a device, a substance, a method, or a process that is new, inventive, and useful. A granted patent gives you exclusive commercial rights over your invention, allowing you to control use, manufacture, and sale, essentially providing a monopoly over what you invent. And I guess there are lots of things that can be patents. So I spoke about devices, substances, methods. I'm talking things like an electric car, or even the components that make up an electric car, a vaccine, various methods or processes for making new things. The list is quite extensive.
Yeah, it is extensive, and we've got quite a lot on our website about that too, haven't we, that the listener can go in and have a look at.
There's some really fun case studies and I really like, we've got a section on like famous Australian innovations, so things like Wi-Fi and the plastic banknotes.
Don't forget the Hills
implant.
hoist, Sam.
Yeah.
And the Victor lawnmower.
I've definitely got a
and the
Hills hoist in my backyard.
cochlear implant.
Yes, exactly.
Yeah. And, I think probably a lot of our listeners don't realise that the polymer banknotes and the Wi-Fi were invented in Australia. And actually, I think Google Maps was invented in Australia as well by a couple of very smart people in Melbourne. So there's lots of things. Australians are natural inventors. When you get a patent, if it's granted, is that only for Australia or does that apply all around the world?
So what we say is that IP systems are jurisdictional. What that means is that there are different IP offices in different countries in the world, and they administer their own rights. So I guess the short answer to your question is the rights granted by an Australian patent only apply in Australia.
Thanks, Lachlan. And that's really important for our listeners to know. Now, what are some of the benefits of holding a patent, Sam?
Yeah, there's quite a lot of benefits to holding a patent. They can really offer a competitive edge to businesses, making them a lot more attractive to investors by demonstrating innovation and providing security. Patents can increase a company's valuation and enhance its reputation, signaling that it's at the forefront of its industry. And they can also be used strategically in business negotiations, such as cross-licensing agreements. I think we've got some international studies up on our website that show that patents and trademarks can increase a startup's valuation by around about, I think it was 20%, especially early on. So as you can imagine, a patent can be really beneficial when seeking venture capital.
And I suppose, that's such a critical thing for a business that's starting up and that's looking for that seed capital or more venture funding to scale as they get going. So you wouldn't expect someone to want to invest in your business if you weren't confident that it was an exclusive invention, right?
Exactly. That exclusivity is so important. Yes, sorry, Lachlan.
Exactly right, Lisa. I guess from the perspective of, trying to get an investor to invest in your business, it strengthens your case a lot to be able to justify that your invention is something that isn't just going to be stolen by somebody else the moment you go to market, right?
Yeah, so important. That's one of the primary criterion for investing, is it something that only that organisation can produce or knows how to do? So the patent helps protect that. But Sam, how long does patent protection last?
So for each patent, it can last up to 20 years generally, but for some pharmaceuticals, that can be extended up to 25 years, but that's the absolute max.
So I suppose this is probably a pretty hard question, but I know our listeners are wondering, what are the basic criteria for an invention to be patentable?
Yeah, so there's quite a lot of criteria in the Act, but there's a few really, really big ones for an invention to be patentable. First one is that it has to be new or novel, and that means that it hasn't been previously disclosed or used in the public domain anywhere. The second big one is that it has to have an inventive step, which means that it can't be an obvious modification to something that already exists. Third one is that it needs to be useful or have a practical application and fall within what we call a manner of manufacture. And that's typically something that results in a physical product or process. Whole bunch of other criteria in the Act, but I'm not going to sit here and list every single one. I'm sure you can find the Patents Act online if you want to see them.
Reading the Patents Act, maybe if you've got insomnia.
That's what patent examiners do for fun.
Maybe they're a bit more of an IP nerd than I am. That's great. And look, I just want to pick up on two things there. The first one is that it must involve an inventive step and can't be an obvious modification. And I have heard you guys talk about an expression that's someone who is skilled in the art of that industry would not expect to see that it's not just an obvious iteration of an invention. Is that right?
Yeah, that's absolutely it. We always look at things from the point of view of a person who is skilled in that art, so someone who knows a lot about that particular type of technology. But this kind of imaginary person, they're not inventive at all. They can just sort of make the normal standard progress in that industry and make obvious modifications to what already exists. But they can't have that inventive spark.
Yeah, they don't have the spark, which I know a lot of our listeners have, and a lot of Australians have. We've just got so many great ideas here. The other thing I wanted to pick up on was that you can't disclose your ideas. So if it can't be previously disclosed, can we talk about that a little bit? Does that mean you have to keep it a secret before you apply for the patent?
Yeah, and this is so important. Anytime I'm chatting to small businesses, I swear I must say this about 5 times. You have to keep the idea secret before you apply for a patent. Even posting about it on your website or your social media can count as a public disclosure, which could mean that you're then never able to get a patent on that idea.
Ooh,
so
scary.
Really important
really
to keep
important.
it confidential before you apply, or even before you decide whether you want to apply. So one of the really, really important tools, I think, for that is making use of things like non-disclosure agreements, because obviously when you're developing an idea, you probably do want to share that with potential business partners or investors and
even
that sort of thing.
market research companies.
Absolutely,
if you're looking to
exactly.
Find out, yeah.
So, but when you're doing that, you need to have some sort of protection that they're not going to share your idea. So, NDAs can be a really good way of doing that. We, as IP Australia, we don't sort of offer or administer NDAs, but we do have up on our website an NDA contract generator, and that can help you get started to recognise kind of the key issues that you might need to look at for an NDA. Obviously, lawyers are also the experts on NDAs, so you can chat to them.
A non-disclosure agreement can sound a bit scary, but you can also just make sure if you're a small business or you're a startup and you're starting to engage with manufacturers, designers, marketing agencies, market research, anyone in your supply chain or your network, if you haven't already applied for that patent, then you need to make sure that they're signing an NDA. Now, Sam, I've heard that a good way to get started is maybe to put in a provisional patent application. Can you talk a little bit about that?
Yeah, absolutely. No, that's another really great option, actually, in terms of protecting yourself in those early stages. It can be a really good option, particularly if you're not sure if you want to disclose your invention yet, because it's a type of patent application that it gives you sort of 12 months to explore the idea more before filing a full application. The provisional application gives you a priority date which counts kind of from when you first put in that provisional application. I think we're going to talk a little bit more as well about provisional applications a bit later in the episode.
Yeah, we are going to. But if you already have an IP attorney that you're working with, you could have a chat with them for our listeners out there. Lachlan, we talked a little bit about some of those earlier inventions, Wi-Fi, the cochlear implant, the polymer banknotes, all fantastic things. There is some top talent out here in Australia, as we can see. How can someone find out if they've got this great idea? How can they check that it is novel, it is innovative, that it isn't just that iterative step on another idea?
Well, what we at IP Australia use to, I guess, assess those qualities that Sam was talking about earlier, that novelty, that inventiveness, we look at what other people have done in the world already. So we look at what's called prior art. That can be any kind of information out there related to your field of invention. It can be other patents, it can be scientific papers, it could be, newspaper articles, really anything. So I guess the best way for somebody to find out if their idea is novel and innovative is to do their own search of that prior art. Do a systematic review of existing patents, patent applications, any other public document. And that way you can determine if your invention idea has already been disclosed or discussed or, maybe even obvious. That can involve checking patent databases, using things like Google Scholar, really anything, any way that you can use the internet to help you search counts. On our website, I think I mentioned you'll find our Australian patent search. You can also use Google Patents or the European Union patent database, eSpaceNet. All of those are completely free to use, by the way.
Oh, that's fantastic, and we love free. Free is good. Look, I meant to mention earlier for our listeners that anything that we talk about in today's episode, we will pop a link into the show notes. So don't feel that you've got to hastily scribble anything down, particularly if you're one of the 10 million Australians that likes to listen to podcasts when you're walking. So all of those links will be there for you. So I just had another question about the patent. So it sounds to me that essentially it's a bit of a trade-off. You get exclusive rights to your invention in Australia in exchange for publicly sharing your invention, and it will be loaded onto those databases that you talked about earlier to promote innovation. Have I got the right idea there?
Yeah, absolutely. I think that's exactly it. It's really a trade-off that an inventor can get that 20 years of protection of their idea, and in exchange they share all of the details of how it works, and that then becomes part of the public knowledge that everyone knows how to do, and people can't make use of it for that 20 years necessarily, but after that 20 years anyone can then potentially do it. And the idea there is that disclosure helps promote innovation by allowing others to learn from your invention, build upon it, or find alternative solutions.
Yeah, and maybe take that next novel or innovative step. If someone doesn't want to get a patent because they don't want to publish, they don't want their invention published, what other options do they have to protect their IP?
So I think one of the really big options that's used there is trade secrets, which is another type of IP, but not a registerable type of IP. And that's one of the most common sort of examples of a trade secret that we often talk about is Coca-Cola. The Coca-Cola formula has never been made public. And so it's been around a lot longer than 20 years, but it's still protected because nobody knows what it is. So that's can be a very, very effective form of protection.
Yeah, I think there might be some herbs and spices too that might be protected. Sorry, Lachlan.
And if you want to protect something like a trade secret, that's when you make liberal use of those NDAs that Sam was talking about earlier.
Yeah, and it all comes down, doesn't it, to recognising what your intellectual property is, what intellectual property your business holds, and how you want to protect it, and then selecting the right mechanism to protect it, depending on what you want to do.
Yeah, and it can often be a combination as well. I was chatting to someone this morning about Lego's patents and how they, originally the block was protected by a patent on that particular type of block. But that was obviously many, many years ago now. That patent has since lapsed, but now Lego's brand is much more about the quality of the brand, that when you see that Lego trademark, which I'm sure is covered in another podcast, you see that Lego trademark is protected by that you know that that's Lego quality. So the fact that their patent doesn't protect them anymore doesn't matter so much because it's all part of their overall IP portfolio.
Yeah, and having that IP strategy for your business. So, and backing yourself, I guess, as a startup, that this is something your business is going to have longevity. It's not just going to be a flash in the pan and looking at what you want to do long term. So I think we call that a portfolio of IP rights. Is that right?
It sounds good to me.
And we do talk about trademarks in episode 2 of the IP Australia podcast. So don't hesitate to finish this one and then hop back and listen to episode 2 if you haven't had a chance. Let's talk about those provisional patent applications that we talked about a bit earlier and what role they play in the patent process.
Yes, so a provisional application is a really great first step. As I mentioned, it gives you that priority date, which is really important because it establishes who was first to file that invention. And then it gives you 12 months to further develop your invention, test the market, decide whether you want to file a full or what we call a standard patent application. And the provisional is generally quite a lot less expensive than the standard application. And it lets you then potentially publicly disclose your invention without jeopardizing the chances of obtaining a patent later.
Yeah, that priority document, that priority date is really useful because we will only assess a patent application from what we call the priority date. It's essentially where you plant your flag and say, this is where your invention had its origin. We can't really use documents after that point unless there are really special circumstances. A provisional patent application also paves the way for international protection. You know, we spoke about having an Australian patent only for Australia, but if you have a priority patent application, you can also choose to file in other countries within the 12-month window of that provisional application existing. It's a really big advantage to be able to get that foothold into a different country.
Lachlan, can I just ask you a question there? I'm sorry to interrupt you. For our listeners who might not know, and possibly for me because I don't know either, are the details of the invention disclosed if you file a provisional application?
What we say is that you need to have enough information in that provisional application to reasonably demonstrate that it's the same invention that you eventually file for in a full application. If you change the details of your invention, that's totally fine. But what it means is that you didn't necessarily plant the flag at that initial date of those aspects of the invention you want protected. So that's definitely something that you'd have to think about before filing your provisional application.
But it doesn't necessarily get published. If you decide not to go ahead with that provisional application, it then lapses. It never goes up on those Australian patent databases that Lachlan discussed.
Yeah, that's what I was getting at, because I'm just thinking maybe if it was me, and I am not an inventor, we'll just make that perfectly clear here, but if I was inventing an idea and I filed my provisional application, or I used an IP attorney to help me to file the provisional application, and that was then published, and then I decided not to go ahead with a standard application, there's other people are going to see that and maybe just piggyback off it and, basically take my idea. So that's really good. Thanks, Sam. But you do have to have all your ducks in a row. It's not like you can pop a provisional in as a placeholder. It really has to have all the claims and be well on its way to being a fully formed application, right?
It does. The provisional application isn't going to give you any patent protection on its own. It's not something that you can kind of go and enforce. You can't threaten legal action or anything based on a provisional. If you want to have that kind of protection, it does need to then be followed up with a standard application.
So a provisional application is just that. It's not a provisional patent. Now, Lachlan, you were talking earlier about something called an international type search that I got a bit excited about. So would you mind sharing that with the listeners, please?
Yeah, well, if we're talking about economical options, the international type search is one of those. It really is analogous to a provisional application, except instead of just having a placeholder, if you request an international type search, you actually get a search. So we were talking earlier about making sure to understand the landscape of your technology and whether there are any competitors that you want to be aware of. Us doing an international type search undercuts half the work that you might need to do. It gives you insights into similar patents and technology trends. So what we'll do is we will look for any inventions similar to what you would like to get. We'll provide you a list of prior art documents relevant to the field of the technology and relevant to your invention as is broadly described in the search statement you provide us. And then we provide you a final analytics report that gives you some interesting trends in that area. That international type search can then be your provisional application. So you can turn that into a variety of different patent applications. But still, let's just say to make a decision within the 12-month time frame of provisional applications, it's a good idea to request your international type search within 10 months of making your application. The fee I've got right here for the international type search at the time of recording is $1,100. And again, this international type search is not something that becomes public, so you can freely request it and get that information without disclosing anything to the public of what your invention is.
We call it a search, but it's actually even more than that, because we do the search, but we also do a full examination. And so we highlight any other issues that there could be within your application that might need, potentially could need amendments before it goes ahead to a complete application. We'll highlight any of those there.
I just want to let our listeners know that we do have a service. If you've not engaged an IP attorney, we do have, it's called a small medium enterprise patent case manager service. You can hop on the website and have a look. That's a team that is qualified to speak with you and talk you through the process of either applying straight for a standard application or going through a provisional application. That's available to you from IP Australia, or of course you can access any of the fabulous IP attorneys that are available to you. Sorry.
That case manager program, that's all examiners that do that. So they're bringing all of the expertise of all of their examination knowledge to help you understand what options
and there's
are.
some smart people in that examination team, as I know, because I have two of them right here. So let's just talk a little bit more about things that we know we hear from small businesses that talk to us at events and ring us and ask questions. People always ask the question, is there such a thing as a worldwide patent?
Yeah, I've definitely got that question a few times. And I always have to say, no, not exactly. There's not really any kind of single worldwide patent. That would make some things easier. But the closest thing we have is something called the Patent Cooperation Treaty, which we generally just call the PCT. And this is something that makes it a lot easier to apply in multiple different jurisdictions. It's basically a single application. It allows inventors to file that one application in one language, and it has the same effect essentially as filing individual applications in each of those PCT member countries. So currently, I believe there are 158 PCT member countries. It basically covers, most of the world's major markets, or almost everything. So it doesn't kind of grant you then a worldwide patent, but it really simplifies the process of applying in multiple countries. It is really important, though, to be aware that it's definitely a more expensive option. The costs kind of depend on various factors, but it can definitely be thousands. So you'd want to consider it carefully before you apply, and you need to be prepared to then kind of follow through on your application and potentially the enforcement of that patent in multiple different countries with multiple different laws.
Oh yeah, I think we're getting right down into some heavy stuff there. So I'll just pause you there and just let the listener know that there is a lot of information too about exporting and about the PCT and everything on our website. And we will talk a little bit more about that because we do have Patents Part 2 in episode 4, which, we really encourage you to listen to as well as this one. So while we're talking about costs, and we know that for a scale-up, particularly a startup or someone who's bootstrapping, the costs are so important. Lachlan, I'm just going to throw this one to you. Talk to us a little bit about what our listeners might expect to pay.
Lisa, I hate to say this, but I don't have a concrete answer for you. I wish I did. But costs for patents can vary quite a lot. You might spend hundreds to thousands of dollars depending on things like the number of claims you've made, whether you've applied for a provisional application, whether you've asked for that international type search. All of those costs are detailed on our website, but there are even some additional costs over the course of the experience. For example, we can't provide any information on the kinds of costs that a patent attorney or other IP professional might charge, and that will vary depending on who you might seek out. There are also renewal fees. So to actually maintain the validity of a patent within its term, to make sure it's something that we call in force, active, annual renewal fees have to be paid. And that starts from the 4th anniversary of filing a standard patent. If you don't pay those renewal fees, then your patent, even though it's granted, lapses and it has no protective power anymore. Then there's also the enforcement cost, because just having the patent, as we said, doesn't automatically give you any protection. You have to actively go and protect your invention. So if someone infringes your patent, defending it can be expensive. All the cost information that we can provide is on our website, but like I said, it doesn't tell the entire story.
As far as I'm aware, though, patent attorneys, I think some of them do definitely offer free consultations as well, though. So if you're not quite sure about those costs, certainly you can reach out to patent attorneys and I'm sure they can give you more information there.
Yeah, thanks, Sam. I was just going to talk about that IP professional piece. So the Institute of Patent and Trademark Attorneys have a page where it's got a little bit of information in there about a free consultation to talk about anything that you might want to discuss confidentially, of course, because that's a good way to start. But if you've got a question, don't hesitate to call our fabulous people on our helpline. The number's also in the show notes, and they can answer any questions that you have about any of these things and provide you with more information. Now, Lachlan, you've used a word there that I'm not terribly familiar with, and I don't know that our listeners would be familiar with either, and that's claims. What exactly is a claim when we're talking about a patent?
Well, a claim is possibly the most important part of a patent application. The claim itself is the language that sets out the boundaries of your invention. In other words, it states exactly what you've invented and what the scope of your monopoly is going to be were you to get that patent granted. The language of the claims can allow you to expand the scope of your monopoly beyond precise examples if what you have invented contributes more broadly to the art. But equally so, if your claim is too broad, it might start to infringe on the scope of other patents.
So it sounds incredibly complicated but very important.
Claims are so tricky, and a lot of the time when we see claims from people who have not gotten professional help, they can be a bit like that, Lisa, and that can be a problem for us.
Which is not right, obviously.
Unfortunately, claims can be so complicated. But I know we do have some examples on our website of what claims can look like across different technologies, like in a mechanical area or a chemical area, what a claim might look like in that. So I would definitely have a look at those examples.
So look, someone thinks that they're ready, they've got their invention, they know what they want it to do, they're pretty well along their way with the development of it, and they think they want to get a patent. What are some of the things that they should be doing before they file their application?
I might take this one, Lisa.
Yeah, sure. Thanks, Lachlan.
Because I don't think that I've said this yet, and I really feel the need to be a broken record. First, you want to make sure that your invention is new and it hasn't been published anywhere before your priority date. We really cannot stress that enough. Check who owns the IP as well. The inventor is not always the owner.
Yeah.
For example, IP created at universities might belong to that institution, depending on what their IP policy is. Staff and students in a university often have a duty to disclose inventions, so make sure you read your university's IP policy and talk to your tech transfer office or commercialization office to make sure you're using that IP right. That concept of universities owning IP applies to businesses too. If you create IP while part of a business, it usually belongs to the employers. So you want to check your contract and policies before applying or taking legal action there.
And I think that's something that most people might not think of, that, you know, they've come up with an idea, but they might have come up with the idea in the workplace or in a university situation. So we've decided we want to get a patent. We've checked that it's nobody else has filed anything like it, that there's nothing else like it that we can find. What are some of the steps that people can take when they're ready to go?
So the first thing that I'd say is to start by considering whether you want to get an IP professional involved. They're the people who, they know all about IP strategy and they're able to give advice. At IP Australia here, we love giving information, but we can't give advice. So someone like an IP attorney or other IP professional, they can help with, as I mentioned, strategy, doing those searches that Lachlan was talking about. They can draft the application for you. They can help with confidentiality agreements and also with international protection. So we sometimes say, it's a bit like having an accountant, but for your IP. If you've got a small business, you probably don't try to do all of your, tax and everything all on your own. You've probably got an accountant to help with that. IP professionals are the same for your IP. If, though, you're a small or medium business who is applying to us without an attorney, you can request, as Lisa mentioned, that patent case manager. It's a free service from IP Australia, and it gives you a dedicated contact to an examiner like me to help guide you through the process. But I think we might have mentioned They can't give legal advice like an attorney can. It's just to give you that information. So the other things to do before filing, I guess, would be, as Lachlan mentioned, doing that prior art search, using all those tools we mentioned. And a patent attorney can also help with that. They can, conduct those searches for you. Once you're satisfied that that idea that you've got is unique, the next thing that you'll need to do is put together a patent specification. And this is the document that contains all of those details of your invention and how it works, as well as those claims that Lachlan spoke about, which outline your legal monopoly. So IPS attorneys are really the experts at putting those documents together. But if you're doing it yourself, as I said, definitely encourage you to have a look at those examples on our website, because it is not the most intuitive document to put together. Look at the other patents in your field. If you're working in a particular area and you're doing that search to find out what else is there, have a look through how they've written their patent applications. Obviously, you can't copy them, but it'll definitely give you a bit of an idea how it works.
Yeah, and how it's worded. That's a great idea. Thanks for that, Sam. Now, look, I know that there are going to be, as I mentioned before, some of those bootstrapping startups. They're just not going to have the funds to engage with a patent attorney, so they're probably going to go ahead with their application themselves. What might that look like for them?
Yeah, you can absolutely apply yourself. It's just obviously a bit more challenging. You need to really, really understand all those legal requirements, and you need to prepare everything yourself. I think there's a few things we've mentioned over the course of this chat where there are, deadlines involved and information you need to provide. And if you don't provide that, it can then mean there's no way to correct it. So that's where you really want to make sure you understand all of those legal requirements beforehand. And that's where that small, medium enterprise patent case manager program can help you understand those requirements.
Yeah, and look, listeners, we do sound, what did you say, Lachlan, a bit of a broken record. We will say the same thing over and over when those things are really important, and we really want you to take them away. So let's talk a little bit now about any potential risks or downsides to obtaining a patent.
There are a few risks, Lisa, which I think that potential applicants should think about before they actually do apply for a patent. The process is time-consuming. There can be years between applying for a patent and actually getting a granted patent, and it can be costly with no guarantee of success. Also, the trade-off for applying for a patent, trying to get that patent protection, is that you make your invention publicly available. So if you do that potentially at the wrong time, you run the risk of signaling to your competitors, even providing them aid of what you're doing. That protection only lasts for 20 years as well. So what the risk is there is that if you've not got your strategy set or in place, you could run the risk of the patent expiring before you can make any meaningful progress in commercializing it. And I guess then there's that final thing that I said earlier, which is that to protect your invention using a patent, it is a proactive thing. You need to identify and enforce the rights of your patent, which means that you have to spend the time and money doing that too to actually really maximize your protection.
Well, honestly, I think we've just shared so much information with our listeners today in that episode. We might call it there. We are going to go into another episode, sort of part 2 patents, which is episode 4 of the IP Australia podcast, Because IP Matters. So Sam and Lachlan, you'll be joining me for that one too, won't you?
Yeah, absolutely.
Wouldn't miss it for the world.
Can't keep them away. Thank you so much for your time today. Honestly, I think you've given so much great information to our listeners, and hopefully we've given people some really great tools and resources to access and have a look at, and to educate yourselves a bit more about patents so you can make a great decision about whether your invention is ready to go that way or not. So thanks for joining us today on the IP Australia podcast. We'll say bye for now, and we'll see you on the next one. Thanks again for tuning in. I hope that gave you a good starting point for protecting your invention or innovation. And just a quick note, the content shared in the podcast is not intended to be taken as legal, business or other professional advice.